All right, we are live. Welcome, everybody, to the Gunner Technology Livestream, a weekly tech talk for non-techies and techies alike. I'm your host, Barry Merkins. With me again, Cody Swan, CEO of Gunner Technology. How you doing, Cody?
I'm good. Just another day in paradise. Pretty foggy here today. Actually, I was trying to ride the motorcycle home, and it's like, okay, this is going to be interesting because I can't see anything.
It's a foggy day in Port St. Lucie town.
Foggy day in PSL.
All right, so quick shout out to our sponsor, Country Shore, a lifestyle brand for anyone who loves the outdoors. We have a winner of our weekly giveaway. Let me mute my computer real quick. Done this a couple times now. Tim M from Atlanta, Georgia. You got a hat coming your way. Congratulations. Anyone who wants to enter, sign up on our Facebook page. Get some cool Country Shore swag coming your way. Our topic this week is, well, I guess our question for the week is, what effect do patents have on the technology industry? So Cody, take it away.
It's an interesting one. It's a broad area, and there's a lot of room for personal opinion here. So I guess it's good to start off with an explanation of what patents are versus other types of intellectual property protection. The kind of most basic is copyright protection. And you see that mainly among digital media, or what am I thinking of? Like movies, music, things of that nature have copyright protection. Books will have copyright protection.
So basically creative IP.
Right, exactly. Well, exactly. And I was going to kind of say that's for trademarks, but it applies to copyrights as well. And what people don't understand about copyrights is they literally apply to copying something. So if you take something, you take a movie, for example, and kind of change it by 10%, it can be a parody. If you take software, for example, if you take someone's code directly and you use it in another application, you have violated copyright law. But if you take their code and you change it significantly being a legal term, you have not violated copyright laws.
So that's where fair use comes into play. I mean, I see people complaining all the time about stuff they've made being posted and then taken down, but that should fall under fair use. Basically, it's a use of existing media that's been transformed in such a way that it's an original product or an original creation.
Yeah. That's 100%, and that's why reverse engineering is completely legal. You can reverse engineer something and not violate copyright law. Trademark law is very similar to patents, although it protects like names. You trademark a company name. It doesn't protect bodies of work. It protects more like names. So when you see that TM or that R, those are trademark restrictions. So
if I wanted to start a company called Coca-Cola Software, that would probably not be allowed under trademark law.
Well, interestingly, I think you'd be kind of in a gray area there. It wouldn't absolutely be a violation of the trademark because you are using it for something that is not in the same
related realm. What if I wanted to start something called Microsoft 2? And be a software company.
Yes, then you definitely would be. And by the way, that you may be even in violation in Coca-Cola. It depends on what their trademark covers, their areas of their trademark. So, for example, we're talking about one of our clients, Country Shore. Country Shore has a trademark on the name Country Shore, but it applies to clothing and apparel. So there's a Country Shore resort, camp and resort. They are not violating the Country Shore's trademark because they are in a unrelated industry. So when you file for a trademark, you kind of say how broad or narrow you want that. So Coca-Cola could be very broad, and it could just be carte blanche at this point. And one thing that I don't remember on the, and I always get these messed up, is how long these last, because each of these has an expiration. I want to say copyright is 50 years, trademark, I don't remember, and a patent is 10 years. So they all have shelf lives. And recently, I want to say Disney's copyright ran out on a lot of characters like Donald Duck and Mickey and things like that. And I think you can apply to renew these things, but they don't automatically last forever.
Well, that's an interesting angle too. It might be an interesting side topic, is the fact that most of these laws were written before a lot of corporations' legal standings had been established. So my understanding is a lot of these laws were written to protect individuals and their rights for their creations, basically, so it would be during their lifetime. But what we have now is corporations whose lifetimes are seemingly infinite until they go out of business. So a lot of these patents are basically never ending, whereas before they were supposed to sort of expire when the patent holder expired, for lack of a better term.
Right. And it's kind of, as we said about most things, is it's a great system until humans get involved, and then you start seeing
right.
seeing the flaws in the design or the flaws in humanity, depending on your point of view. But the last one there is patents, and I'm almost positive that a patent has a 10-year lifetime. And so a patent protects an idea. So again, to explain the big difference between patents and copyrights, if we write an application, something, I'll just use an example we talked about, for an application for active shooter situations, to help people in active shooter situations. And we can't copyright that idea, but let's say we write that application and we copyright, what we would actually copyright is the code for that application. So we develop the application, we copyright the code, and then Gunner Technology comes along and releases an active shooter application. They didn't necessarily violate our copyright if they took our application and reverse engineered. And what I mean by reverse engineered is basically they look at the features that are existing and they figure out in their own way how to implement those features. So if they do that, they haven't violated our copyright. At the same time, if we take that exact same thing, an active shooter app, and we patent it, and then Gunner Technology comes along and releases a active shooter app, they have, it's up to a court of law to decide, but they have probably violated our patent for such an application. So when you file a patent, you're patenting certain functionality rather than copywriting specific pieces of information.
And this kind of gets into the actual effect that patents have on the technology industry, because there are actually, and I'm blanking on the name of the company that's famous for doing this, but there's companies that will just buy up patents and then sue the heck out of anyone who is in any kind of breach of that patent. And I think most of the lawsuits actually occur in some weird county in Texas that's very, very friendly to the holders of patents.
Yeah, that's exactly right. And what you're thinking of, I don't know if it might have been TC Heartland. It might be what you're thinking of. But what you're thinking, the term for them is called patent trolls. And so, yeah, what these companies do is they're small companies, right? They're non-tech companies, but they usually operate in the tech world. And so what they'll do is they'll have people just sit around and think of just brainstorm technology. And then they'll try to patent that technology and then never build that technology. So basically what they're trying to do is block innovation from usually bigger companies and force an Apple or a Google to come out and then basically buy that patent from them. To take an example, it could be very possible that around, say, 2000, in the year 2000, a company was sitting around and they're like, oh, wouldn't it be cool if there was this phone that didn't have any buttons and it had a glass screen and you basically controlled it with touch gestures. And so they start patenting these features of this phone. And then in 2006, when Apple comes along and actually wants to build this phone, they'd never seen this patent trolls patent before. And they have this independent idea to build this actual phone and have the resources and capability to do it. They can't because some patent troll is just holding on to this patent with no even feasible idea on how to actually implement it. They just know they're betting that someone someday will have a similar idea and have to pay them in order to build it.
Sorry, I was just fixing the video on our feed, but we're good now. The video was off because I was messing around with OBS. So how can you counter that? Because it seems completely against the original purpose of patents. The original purpose of patents was, or at least seems to be, I built this really cool thing, explicitly built it, put a lot of time and effort into proving that it could be built and that people want it and that it's functional. So I need to get a little bit something back, because, I mean, the issue here is that there's a tremendous outlay of capital, and not just capital, but time and resources that you have to put into even proving the viability of a product. So you'd want a patent on that for some given period of time so that you could get your money back, so that you could, so basically we're encouraging people to innovate and make stuff better. So if patent trolls can just sit on a patent, wait for somebody to actually try and build something, and then jump on them and say, no, we had that idea, even though we were going to do nothing with it, so now you owe us $500 million. What recourse do we have to stop that sort of behavior? Because it seems like it's in no one's best interest except the holders of these patents, who are going to do nothing with them except sue the pants off people.
Right. And it's weird because who have really been the champions against this type of behavior has been the big guys, the guys that we usually don't root for. The Goliaths have turned into our champions on this, because basically for a while, the Goliaths, and by Goliaths, I mean who we usually talk about, the Disneys, the Facebooks, the Googles, the Apples, the Amazons, they were kind of like, okay, that's nice. We'll pay your $500,000, your $1 million, and we'll take over this patent, whatever. It's like 10 minutes worth of our company's time. Here you go.
We're paying these legal fees anyway. Might as well use them.
Right, exactly. So, but patent trolls started to get greedy and really started not only just ramping up how many patents they were filing, but the demand they would impose on these companies when the companies wanted the patents. So the big guys started fighting back. And as I think is pretty common knowledge, in situations like this, it comes down to who has the better lawyers. And it's tough to find a better legal team than you will at, say, Amazon or Google or Facebook or Microsoft or Apple. So they really started fighting to shut these patent trolls down. So that has been one way, is to kind of try to scare them out of existence with bigger lawsuits against them, like basically counter lawsuits. The right answer is a lot more complicated. I mean, in terms of how do we fix the patenting process? And by the way, just as an aside, if anyone's familiar with domain squatting, which is kind of where you're like, oh, I bet Widgets XYZ is going to be a popular company in a few years, so I'm going to buy Widgets XYZ and just wait for that company to become big and then charge them a lot of money for that domain. So it's the patent trolling is very similar to domain squatting. Except you're squatting.
Yeah, I knew a guy in DC who did that. He made a pretty good living just buying up domains, squatting on them, and then waiting for companies to pay him tens of thousands of dollars for those domains.
Well, that's right. And again, to take an example that we've had firsthand, countryshore.com is not owned by Country Shore. It's owned by a domain squatter who wants $20,000 for that domain. So Country Shore, the website is countryshoreoutfitters.com. And so
posthost.com, I think they wanted $15,000 or $18,000 for that, something like that, something absurd.
Right. And it's kind of a bluff, right? Because here's the thing. Country Shore now, if you Google Country Shore, you're going to see Country Shore Outfitters. So really, Country Shore, and again, it's not much of a bluff because the original domain probably cost that guy 10, 20 bucks a year. And so it's not a huge risk. But now countryshore.com is pretty much useless to anyone except for Country Shore, the company. So it's not a very strong position because you only have one bidder at this point. If you're willing to kind of fight back in that regard and just kind of go the SEO route, because no one is finding Country Shore by typing in countryshore.com. They're finding Country Shore by Googling Country Shore, and then the first, whatever results are all related to Country Shore, the company.
I was just going to say, a lot of this is moot because the landscape has completely changed. People discover stuff on social media as opposed to actually remembering a URL.
Right. That's exactly right. And but to get back to the point of patents, the solution is to kind of have and to take a step back. If you're not sure if you want to get a patent, because patents are pretty expensive, they can usually run in like the $10,000 range to obtain a patent. You get a provisional patent, and a provisional patent is much cheaper. And it's basically like a placeholder for a patent. It's like, I may want to patent that, but I'm not sure yet. And so you can basically put a hold on it for a year on a patent. And so, but that provisional will expire after a year. And I think that one of the solutions to this broken process is to have a similar kind of expiration for patents themselves. Like, okay, you can patent this idea, but if we don't see an actual product if we don't see an actual commercial product within 2 years, you're going to lose that patent, kind of thing. That seems like, and I'm sure you could poke holes in that, but that seems like such an easy starting point in fixing this broken process.
So it's sort of be a two-stage patent process where one is you get a short-term patent where you have to actually do something in a year or 2 or 3, and then a long-term patent once you actually do something for 10, 15, 20 years so you can make your money back.
Correct. And it's even 3 years is a long time. We talked about this in past episodes. Two things that touch on this is that technology moves so freaking fast. It moves so fast, way faster than anyone ever thinks it will, except for the flying car thing. Flying car thing, we were supposed to have that by now, and we just don't. But most other things, you're like, okay, so in 10 years, there won't be any jobs for truckers. But now it's looking like that's 5 years, which probably means it's 3 years. So my point is 3 years is a lifetime in terms of technology. And I kind of, we'll touch on this I'm sure down on this episode, but medicine also, it's a lifetime in medicine as well. When people are trying to, get access to life-saving prescriptions, 3 years on a patent that's blocking that implementation is a lifetime. And so the other thing that this touched on is that technology, innovation rather, always wins. And this is basically an attempt to stop innovation. And again, so it's an artificial construct that's going to be it's going to lose. It's just a matter of when, because anything that kind of stands in the way of innovation eventually falls by the wayside.
Well, except to play the devil's advocate there. I mean, the other side of the coin is we want to innovate, but it costs a ton of money to innovate. So let's just take the medical sphere is actually really interesting because that's where a lot of the cases come from, patents on prescription medication. So if I'm a prescription medication company, like a big company, or not even a big company, I guess it's probably more important for the smaller companies. So if I'm a startup in the, I don't know, let's just take like pain medication field, and it's going to take $100 million to research this new drug and develop it. I'm going to need a couple years to get through that. And I'm going to need a couple years where I'm the only one who's allowed to sell that so that I can make back my money so that it's worth it's worth it for me to even try and do this. I mean, if stuff is limited too much, it might be the case that I know I'm not going to be able to make my money back, so I'm not going to try and innovate any of this new stuff.
Yeah, it's
there's a fine balance there. You can go too small and you can go too large. It seems like there's the happy medium there, and we're just having trouble finding it.
Right. Whenever we talk about patents in medicine and that scenario that you just brought up, it makes me have a renewed appreciation for Jonas Salk, the inventor of the polio cure, because he basically invented something that, and again, I'm not going to do the math to account for inflation, but I mean, multi-billion-dollar patent basically. And he said, nope, I'm not patenting this. No one person or entity should have control over a cure or a vaccine that is so crucial to the world. And so it really makes
I think his quote was, "Could you patent the sun?" That's his famous quote about that.
Right.
He basically said, like, this belongs to humanity. Everyone deserves this.
That's right. And I understand that we're not all as altruistic as Jonas Salk, nor do I think we necessarily should be. I think that, to your point, people should make money from their hard work. And this is where it gets really sticky, because it's almost like we need different patent rules for different industries.
I was just going to say that it gets really dicey with the medical field, and maybe we should peel off of that, because the medical field is so specific to human health and like happiness and their livelihood. So that seems to me there's entirely different rules for developing prescription medications that are potentially life-saving and developing a phone that doesn't have buttons. So maybe just to peel back to the technology side of it, although I guess even on the technology end, there's tons of stuff that improves people's lives that arguably shouldn't be patented and should be open to free competition and innovation.
That's exactly right. And another company that does not file patents, at least, man, I don't want to get this wrong, they didn't patent a lot of their technology, is Tesla and SpaceX. And basically they're saying is the only competition we would potentially have is the government. And by filing patents, you're giving your secrets over to the government.
That's interesting, yeah.
So the kind of alternative is to keep your stuff, is to not patent it and keep your stuff so secret that no one can replicate it. And I've said this to you before, a lot of times I think we should just do away with the patent system. And basically, if you want yours to be the best seller, then make it the best product. So, again, to take the example of the active shooter app, we build an active shooter app, and then Gunner Technology makes an active shooter app. Well, we make ours better. Whatever that means, we make it better. And that moves innovate. That means that it'll be more innovative, and that actually does push innovation harder. Now, the problem with that, again, is that it really can stifle innovation at the smallest level, because if we're going to build an active shooter app and not patent it, it would be so easy for a very large company, a large software company, to come and build an active shooter app and then innovate on it way more quickly than we ever could. So that's just, and so basically we would look at that. We would have a meeting. We would say, it's just not worth it for us to build an active shooter app, because the minute we build it and have success, Google is going to come along and build like active shooter app plus, and we'll have wasted our time completely.
That's so tough. There's really no good answer to that, because sorry, go ahead.
No, I was going to say it's not like it doesn't happen, because we talk about this all the time, is that Facebook, Google, they wait and see what ideas kind of have traction, and then they build those same features. And again, they have really good lawyers, so they get around the patent issue. But they either look at something like Facebook has taken a lot of Snapchat's features.
I was just going to say, yeah, we actually talked about that on our Big 5 episode. Is there sort of the mindset now is either once a product gets big enough or gets enough uptake, the big five swoop in and say, you can either sell to us or we're just going to copy your product. So take a pick. And Snapchat's an interesting one because they're sort of sticking around, but I'm not sure how long that's going to last, honestly.
Yeah, that's exactly right. And so even at that point, they've called your bluff because you may have a patent. We may have a patent for active shooter app, but if Facebook comes to us and says, or forget it, if Facebook doesn't even come to us and says, we love the active shooter app, we're just going to build our own, we're going to be in for an enormous patent fight against them, which would take years and money that we couldn't even touch.
I was going to say that quickly turns into a John Grisham novel where you're just mired in 20 years of litigation and it's costing you tens or hundreds of millions of dollars more than you could ever make from your app idea. So, I mean, you basically have no recourse other than to just give in.
Right.
It seems silly to fight.
And that's why we talk about this all the time is as a small company, you're insane if you turn down Facebook's offer, whatever that offer is. Whatever that offer is, you're insane to turn it down because that means they want what you have and they're going to get it one way or another. So and then when we have that discussion, then I go back to, well, we shouldn't have patents at all then because they're kind of pointless for the little guy. And that's really who they're protecting is the little guy. But if they can't, if they're not working, then why do we have them at all?
Maybe it's important for the big guys. Protect the big guys from each other because there's tons of patent fights. Apple and Google go at each other all the time.
All the time. Apple and Samsung, Google and Uber. There are a lot of patent fights. But again, it's like I think of like the Olympus gods fighting overhead, and it's like kind of like, okay, like this has nothing to do with us. I don't know. I don't know what the recourse. I don't know what that would look like if there weren't patents. If there weren't patents, they'd still be fighting. But again, those guys, and we talked about this in our Big Five episode, on the same lines, a lot of the innovation does not come from these big companies. They either copy it or purchase it. And without these patents, they wouldn't be putting a lot of money into lawyers. They wouldn't be resting on their laurels. It might force them to innovate on their own, which I don't think would be a bad thing either.
Yeah, that's the outsourced innovation that we talked about, where they really just say, we don't need to spend our time in this because everyone else is spending their time in this, and we'll just buy them or copy their ideas down the line.
Exactly. Let someone else take the risk. Why not?
It's interesting. It's tough. I guess the takeaway from this is basically if you have a good idea, build it and make it the best you possibly can and see what happens. Because patenting it isn't necessarily going to protect you. Maybe all it does is get you mired in a legal case for the next 5 or 10 years and you're out however many millions of dollars. And at that point, since technology changes so fast, your product's probably useless at that point anyway.
Right. And obviously we touched on medicine a little bit. We're very focused on technology here and specifically software. And generally software does not have a big cost component to it in terms of parts. It's, as we've said, it's mainly all labor. So there's no kind of barrier to that idea kind of thing. When you talk about we also deal with a lot of hardware. That's a little bit different in that you have to have some competencies and some outlays of cash to be able to foot the bill for the parts that go along with that. So and again, to come back to, we need some discretion among industries for different types of patents. Because yeah, you're right. If you're in software and you have an idea for a product, my advice to you would be skip the patent because it's going to be expensive for you initially. Build the idea as quickly and as good as you can, and then sell it as soon as there's interest. Sell it because you're running a big risk of holding on to that. Don't fall in love with your idea. Never fall in love with your idea. It is a tool, and if it's good, it's meant to benefit other people. So get it in the hands of whoever can help it benefit the most people, and you still benefit economically from that.
Sorry, I'm looking this up real quick. We actually had a question that actually relates to that pretty directly. The question is, how hard is it to get a patent myself? Basically, I guess without legal fees or going through a lawyer or anything like that.
So I can't say that we have done that. We do have a patent attorney that we go through because part of the patent application, because it's not very difficult to get a patent yourself. You can go to sites like LegalZoom, and there's other patenting services that don't involve attorneys that make it cheaper. Again, I still think it's pretty expensive. I think the patent filing fee is thousands of dollars. So it's not cheap because you're paying for the government to do research on your idea pretty much. So you do have to foot the bill. But again, your patent is only as good as the application. So if you're going to go through the steps of getting a patent, you should probably use an attorney who specializes in patents. So you have kind of as close to a bulletproof patent as you can get.
But realistically, if you're building a tech product, just build it. And if you can't build it, give Gunner Technology a call and we'll build it for you.
That's right. I mean, that's exactly right. And again, we deal with entrepreneurs who ask us about patent advice all the time, and we kind of give them this song and dance we've talked about. At the end of the day, they need to talk to an attorney, and they need to talk to an attorney they can trust, who's not just going to say you need a patent. But yeah, if you have an idea and you can't build it, find someone who can build it for you as quickly as possible. And the other thing that kind of this touches on is the concept of NDAs, because we get asked to sign NDAs a lot of the time. And an NDA is a non-disclosure agreement. And basically, this is kind of like the precursor to a patent. So if we have a company, or it's usually an individual, well, companies and individuals, but we'll take an individual. An individual has an idea for an active shooter app. They have no idea how to build software or write code. So they contact Gunner Technology and they say, hey, I have this idea for an app, but we want you to sign an NDA. Well, that's tough for us to do based on no information like that. We usually have to say, well, what does this involve? Because if we sign an NDA, that means we can't we can't build that idea ourselves, and we can't take another client who has a similar idea and build their idea for them. So before we agree to an NDA, we have to have some idea of what we're talking about, because we could have already talked to someone about an active shooter application. We could already be building an active shooter application, and by signing that NDA, then our active shooter application is worthless. So the NDA is basically a promise that says you won't act upon this idea, you won't disseminate this idea. This idea is mine, and you can't basically take it. So again, if you have an idea, and by the way, NDAs are even dicier than patents. We kind of uphold a standard at Gunner Technology, but NDAs are very easy to get around. So they're not affording you much protection whatsoever. So just know that your best bet is to have kind of a solid idea and be able to act upon it quickly.
And we promise we're not going to Zuckerberg you if you come to us with your amazing idea for a new piece of technology.
No, but we may Winklevoss you.
All right, so we'll end it on that note. Check out our podcast on iTunes. We got ebooks up on Amazon, Barnes & Noble, iBooks, and basically everywhere else ebooks are sold. Our blog post on gunnertech.com. Keep an eye out for that. It'll be up next Wednesday. Check us out next Thursday, 1 p.m. Eastern time. That's going to do it for today. Thanks for joining us. Thanks a lot, Cody. We'll talk to you guys later.
Later.